We can call court to order. All parties are ready to begin.
Good morning, everyone. The case being called is Shopping Mall and NY LLC, bankruptcy number 19-23178. Today, we're scheduled for an expedited motion for entry of an order approving a private sale of the debtor's real estate property, free and clear of liens, claims, and encumbrances pursuant to settlement agreement, document number 483. We also have a motion for order approving settlement agreement pursuant to Rule 9019 of the Federal Rules of Bankruptcy Procedure at document number 485. I will call your names and then tell me if you're here, and then I'll ask if anybody's name was not called. Kirk Berkeley.
Kirk Berkeley here on behalf of the debtor, Judge.
Thank you. Brian Butler.
Good morning, Your Honor. Brian Butler on behalf of the Janesville Dewitt Central School District in the town of Dewitt.
Thank you. David Capriotti.
Good morning, Your Honor. David Capriotti, and my partner Wendy Kinsella is with me in my office on behalf of the County of Onondaga and the Water Environment Protection Department.
All right. Mr. Donato's not here. George Fetting. You're muted, Mr. Fitting. I do this all the time. Don't worry.
Had so much practice by now. Good morning, George Fitting on behalf of Onondaga County and the Onondaga County Department of Water Environment Protection.
Thank you. David Ross.
Good morning, Your Honor. David Ross on behalf of Beacon Commercial.
Daniel Schmeezy.
Good morning, Your Honor. Dan Schmizzy for the Janesville Central Dewitt School District and the town of Dewitt.
George Snyder.
Good morning, Your Honor. George Snyder on behalf of 3649 Erie LLC.
Sarah Weinrich.
Good morning, Your Honor. Sarah Wenrick here on behalf of the debtor.
All right, I'm going to try to say this right. Sarah Thames.
Thank you, Your Honor. Sarah Thames on behalf of Janesville Dewitt Central School District in the town of Dewitt.
Thank you. Brian Thompson.
Good morning, Your Honor. Brian Thompson representing Brown, Duke, and Fogel.
Desiree Yagan. Ms. Yagan, are you present?
Judge, she is on the line. I'm having a difficult time unmuting her. Bear with me, please.
Okay. Is there anyone else that wants to enter their appearance while I'm waiting for Ms. Yagan? No. All right. Let's just wait. I think she's coming in through telephonically.
She is on the phone, Judge. Haley, any suggestions?
Donna, I do think when you call in on the phone, there's something you can press. It might be star something. I can't recall. I can see if I can try to find it, that she could unmute herself.
Your Honor, I believe it may be *6 for her to unmute herself.
That sounds familiar. Thank you.
Desiree, I'm sure you can hear us. Please press *6. Judge, while we're waiting, I'm going to call her on my cell phone.
All right, we can hold on.
Thank you. Bear with me, please.
When we start, Mr. Berkeley, we'll start with you so you can give us a summary of everything, but let's wait for her to get on.
Judge, just a housekeeping matter, Ms. Wenrick is going to be presenting for the debtor today.
All right, great. Ms. Wenrick, you're on. So you heard what I said. You'll go first.
Yes, thank you, Your Honor.
Judge, I just talked to Miss Yeager, and she's going to call in again. She said she can't hear anything, so she's going to try again.
All right.
Thank you.
Thank you.
Desiree, can you hear us?
If she can't connect through us, can anybody suggest something else? What about her calling somebody's office and connecting through them or some other way? I don't know. I can't think of anything, but she definitely filed a response and she wants to speak. So
Hang on 1 second, please, Judge.
Judge, can your courtroom deputy just put her on speakerphone?
yeah, I wonder if we could do that.
I can try. I don't know because I have a headset on. I will try. Bear with
And
me.
if that's the way we go, make sure she's getting recorded.
If she's the 315 number, it looked like a second ago, like Zoom had put the little yellow box around her as if she was about to talk.
Oh,
Yeah, that's happened a couple of times, Your Honor, that it looks like, when you're the speaker, your picture comes up,
yeah.
that it looks like she has been able to at least connect enough to have that happen, as Mr. Berkeley pointed out. So there it is again, actually. I'm wondering if she can hear us.
Miss Yagan, can you hear us? Miss Yagan? I see what you two are saying. I don't see her, but maybe I can move it. Oh yeah, I see a phone. Miss Yagan, are you present? She doesn't look muted to me. Usually you have the muted.
Yeah, she is not muted, I'm sorry.
Judge, this is Haley.
Yes.
I believe Donna is going to have Miss Yagan call her, and we're going to try the speakerphone. I'll let everybody know if I'm not picking it up in the recording.
All right, or tell us when you are picking it up.
Okay, that sounds good. Thanks.
All right. My screen shows the phone is on, so you're right, Mr. Berkeley. I don't know.
Yeah, it looks like it's working.
We had a pro se on the phone, I think it was last Thursday or Wednesday, and it worked fine. They called, wasn't a problem. So I don't know what the problem is today.
Okay, Judge, we're going to try this again. Try this. She has to go through my headset. Miss Yagan? Yes.
Oh,
Can
good.
everyone hear her?
Yes.
Yes.
My name is Desiree Yagan.
Miss Yagan, can you hear me? I'm the judge. Miss Yagan, can you hear us?
Miss Yagan, can you hear the judge?
No, not at all.
All right. Can you hear me now?
Hang on, I'm going to put one of my earphones near the phone. Hold on. I'm not going to be able to hear anything, Judge.
That's all right.
All right. Desiree, please speak.
Yes, my name is Desiree Yagan, Y-A-G-A-N. I'm calling from Syracuse, New York.
All right. This is Judge Bohm. Everybody's entered their appearance. Can you hear me? Miss Yagan, can you hear the court?
Miss Yagan, can you hear the court?
I can hear you right now. I heard nothing else.
Well, we need to proceed today. It's an important day, so you need to figure out how to connect with us.
To test for clarity on this phone conference, which everyone else is participating by Zoom. My name is Desiree Yagan. I filed an objection to the sale of Shoppingtown Mall to the County of Onondaga. I filed that on December 11, 2020 by electronic filing, which I've never done before.
This is Haley. I'm sorry that it's not getting picked up in the recording when she's talking. I can hear her, but
Again, it was filed on December 11, 2020 under duress, having problems trying to scan my letter to the Honorable Judge.
Right, Miss Haley, we got to figure some other ways to.
On Friday, and
yeah.
just for the record,
Miss Yagan, can you please hold on, please? Thank you.
I'll contact IT. I'm not real familiar with the sound settings for when parties call in. Let me reach out and see what I can find out.
All right. We'll keep holding on because we got to build up the record today, and she needs to put it on the record. So let's just wait. Ms. Wenrich, make sure when we get to the sale that you address her objection.
Okay, I will, Your Honor. Thank you.
All right, thank you.
Judge, I'm going to call IT right now, okay?
All right, Haley's calling them too, Donna, so.
Oh, okay. I had to give my cell phone my headphones. I didn't hear you say that.
Yeah, she just said that. She was calling IT to check.
Donna, I sent Gil a message. I haven't heard back yet. Maybe we should call them to expedite this.
Okay, I'm going to put myself on mute here and I'm going to call him.
All right, thank you.
Thanks.
By the way, everyone, this is the first problem I've had in 10 months, 8 months, which is good that we haven't had problems like this. And it sounds to me like it's from her end more than us, but we'll find out. Maybe it is us.
Judge, this is Haley. I still haven't heard back from IT yet. The only other suggestion I could think of real quick is if she's on a cell phone, she could maybe download the mobile app fairly quickly to call in that way on her phone.
All right.
If
Do you
she
want
has
to
a
call
cell
her
phone.
to instruct her how to do it?
I could try
Okay.
if I can communicate with her.
Did she try the *6? Do we know?
Attorney Berkeley, we did instruct her,
Okay.
but I don't know if she heard us.
Okay.
It,
Because that is, you
yeah,
can't talk unless you do that when you call them via phone.
right. It did appear that she wasn't muted this time around.
Yeah, that's right, because we could hear her, but she couldn't hear us, it seemed.
Judge?
Yes.
Kathleen's calling Ms. Yagan, and she doesn't have a headset, so she's going to try to put her through Kathleen's speakers.
All right, good.
And
All
I did have
about Haley being able to record, that's all. Can we hear?
Yes. Oh no, I agree.
We
and
care.
I need to hear too.
Hear us, but let's make sure she gets recorded, you know?
Absolutely.
I'll update everybody after she connects. Thank you.
Good.
Chief Judge Baum, I have Desiree on the phone. Let's see if she can hear everyone.
All right. Ms. Yagan, can you hear us?
Yes, Your Honor. It's somewhat distant, but yeah, I can.
All right, so if you can hear us and we can hear you, I think we can proceed.
Yes,
Everybody-
Judge, it is recording.
All right, great. So let's proceed with the hearing. Everybody's entered their appearance. We are here on the hearing on the sale. Ms. Weinreich.
Good morning, Your Honor. Sarah Wenrich appearing on behalf of the debtor. If it's okay with you, I think it makes sense to start with the 9019 motion since the sale.
Okay. Yes, that's fine.
Okay. So as you're aware, the 9019
settlement for Ms. Yagan, that's the motion to approve settlement.
Yes. Your
Okay.
Honor,
I just have to notify the court. I'm having a real hard time making it out. It's getting a little bit of an echo, and I'm struggling is what I want to say. Maybe it'll get better. Maybe the speaker could be moved closer or something. But I'm having great difficulty hearing.
It is right next to my speaker, so I don't know. I'll pull it back a little bit more. Maybe that'll help with the interference, but.
Okay.
And we'll speak loud, but you can interrupt if you can't hear again. All right.
Okay.
So, Your Honor, as you're aware, the proposed settlement agreement is a result of a successful mediation between the debtor and the taxing bodies, including the county, the water department, the school district of the Jamesville DeWitt School District, and the town of DeWitt. So, if it's okay with you, I'd like to start off by just going through the terms of the settlement agreement, the main terms. So, there's the payment of $3.5 million from the county to the debtor. The sale of the mall and the 2 out parcels and those leases to the county. The debtor will retain the Chili's parcel. It will also have a release of all claims, both pre-petition and post-petition of the taxing bodies. So that is over $10 million of asserted pre-petition claims, plus almost $2.5 million of asserted post-petition claims that would have been admin expenses if they are allowed. The county or its designee will receive an option to purchase the Chili's parcel from the debtor in conjunction with an RFP process. The RFP sale process is to occur after the debtor conveys the mall property to the county, and the county then or its designee will have the option to purchase the Chili's parcel for $1 million. The county will commence the RFP process, and net proceeds of that sale process will be split by the county and the debtor based upon the amount of proceeds received from the sale, the RFP sale. Your Honor, would you like me to go through those different splits to have them on the record?
Yes.
Okay. So this is just for the net proceeds. So of the first $4.5 million of net proceeds, the county will receive 90% of those net proceeds, and the debtor will receive 10%. If the net proceeds exceed $4.5 million, then of those net proceeds from $4,500,001 through and including $12.5 million, the county will receive 80% and the debtor will receive 20%. If the proceeds exceed $12.5 million, then of the net proceeds from $12,500,001 through and including $16.5 million, the county will receive 70% of those net proceeds and the debtor will receive 30%. And then for the net proceeds, if net proceeds exceed $6.5 million, then of those net proceeds exceeding that $16.5 million, the county will receive 20% and the debtor will receive 80%. So those are the main terms of this agreement. It is subject to the legislative approval of the taxing bodies. I know that the county has approved it as of December 1st. So we're moving forward with that as well. We believe that this proposed settlement agreement satisfies the Martin factors. And as to the settlement agreement itself, there were no objections to that or the 9019 motion to approve the settlement agreement. So we believe that it's in the best interest of all parties involved based upon the benefits that the debtor and the estate gets from the settlement. Are there any questions that you have regarding the settlement agreement? Would you like me to go through any of those Martin factors, or should I move to the sale motion?
I think you should go over the Martin factors, but I do have 2 comments for you in a few minutes. They're just comments.
Okay.
All right.
So with regard to the Martin factors are: courts look at the probability of success in the litigation, difficulties to be encountered in collection, complexity of the litigation, and expense and inconvenience, and delay necessarily attending to it, and the paramount interest of the creditors. So while the debtor is confident in his position in litigation, litigation always poses a risk. And that's something that we would like to avoid. And we think that this settlement agreement provides a great benefit to the debtor. And we also avoid that risk then. As set forth more fully in the motion there and the settlement agreement, there are numerous disputes between the debtor and the taxing bodies. They are very complex disputes. They have already caused a lot of expense, inconvenience, and delay at this point. If we were to move forward and continue to have to litigate those and go to any type of trial, that would result in further delay and further expense for all parties involved. Additionally, we believe that the settlement agreement is in the best interest of the creditors and all parties involved. We have that $3.5 million payment at the time of conveyance. And then we also, the debtor will retain that Chili's parcel and continue to accrue revenue from the lease of the Chili's parcel. And if the RFP process results in the buyer wanting to obtain that Chili's parcel as well, then the debtor would also receive another $1 million at that point for that option. And finally, well, I guess not finally. Finally, with regard to the sale process, they would also get the split of the net proceeds as a result of the RFP process. But I think it is also very important to note that the claims that will be released against the debtor are significant, and to have those resolved going into a consensual sale process, which we now think that we can achieve if this is approved, is very beneficial for all the parties.
All right. Let me point out a couple things. First of all, in looking at the settlement agreement under Part 1, Section A, it says the conveyance of the county, including the transfer of all right, title, and interest. It says including. I think it should be excluding. The conveyance to the county. Do you see where I'm at? Number 4. Maybe I'm wrong.
I don't think you're wrong.
Okay. It can be a typo. I mean, it just, but it's significant for you people.
Yes.
Okay. All right. All right. Next. Under the miscellaneous provisions of the settlement agreement, the addresses for the town and the school district will need to be provided, correct?
Correct, Your Honor.
Okay. So when that's done, you can, I'm just checking off my notes here. We need to have a record right now of the matters that are the resolution of the items pending in the court and state courts. That was, what about the matters that we have scheduled for 114? If you look at number 7 of the settlement agreement, when is that going to occur? It's upon consideration, upon consumption of the agreement and conveyance of the property, STM, and the taxing bodies as necessary shall withdraw pending motions and adversaries.
So, I'm sorry, Your Honor.
Yes.
With regard to the hearing on January 14th, I believe that is the motion to allow the late filed claims. We did also file a stipulation.
Yes.
So if Your Honor approves the settlement agreement and the 363 motion, I would think those would be withdrawn almost immediately. Any objections to that we could move?
Well, I wasn't as concerned about that. It's the state court action and the rulings that have to occur through there. See, it says shall withdraw pending motions and adversaries. I understand. Involve the taxing bodies, including but not limited to the applications for administrative expenses, the 505 motion, and the adversary proceeding. But what happens to the state proceedings? We'll put Mr. Capriati on in a minute.
Yeah, Your Honor, if I may. So the state court proceedings are and Mr. Butler can weigh in this as well. The state court proceedings are going to be resolved actually through an agreement between the county of Onondaga and the town of Dewitt, to the extent that we're going to stipulate to an assessed value of the property, which will occur essentially simultaneously with the transfer of the property from the debtor to the county. So Judge Greenwood has been made aware of it. The trial when we resolved this in mediation, the trial was adjourned, and perhaps Mr. Butler can confirm. I think it was adjourned out to probably mid-January to allow these settlements to go through. Once these occur, then a stipulation will be provided to the New York State Court regarding the assessed property as of, I believe it's tax years 2020, 21 through 2024, I believe it is. I may have that year wrong. Brian, is that correct?
Yeah, that's accurate with respect to the tax years. Judge Brian Butler for the town of Dewitt and the Janesville Dewitt Central School. So Mr. Capriati is correct. That Judge Greenwood and the state court actually took the trials off the trial calendar. We have a report date back in the middle of January, and if this settlement is effectuated by then the parties, as Mr. Capriati suggested, the parties will enter into an agreement to resolve those tax certiorari proceedings, and those the settlement of those proceedings will then set, pursuant to New York law, the value of the property for the next 3 tax assessment years, which Mr. Capriati correctly noted will go through 2024. So as of now, Judge, those are in a holding pattern, awaiting the conclusion of this process and the sale process to the county, but then those will be resolved after that.
All right, that answers that question. Next one. The $3.5 million, the debtor, well, I presume the debtor's law firm will be holding. How is that money going to be, where is it going to be deposited? How is it going to be protected? Is it insured depository? How is that going to be held?
Your Honor, I believe the money will be transferred to our firm and held in our account there until further order from you. Mr. Berkeley, is that correct?
Judge, the money when it comes in, well, let me say this. We're currently in the process of setting up appropriate escrow accounts to hold the funds. Hopefully interest bearing, although currently today there's not much interest being paid by banks. If it's not set up by the time of the closing, it'll be held in our firm escrow and distributed only pursuant to orders of court, and then eventually through what we hope to be a confirmed plan.
That's fine. What I'm concerned about is that they'd be protected funds. You know that the banks only insure up to certain amounts.
Absolutely, Judge. They will be. And that's one of the things we're working on right now with a couple of banks to make sure that we can get that set up appropriately.
All right. That's good. As long as it's out there being worked on.
Absolutely.
What is the anticipated timeline for the county to conduct the sale of the property pursuant to the formal request for proposed sale process? What are you projecting?
Your Honor, we don't have a definite timeline yet, but the anticipation is that we close this certainly by December 31st, and in earnest begin the RFP process in January. We certainly want to provide enough time for a robust market and a marketing process, but I would anticipate that we're looking at a sale probably May in that area. But again, we're going to let the RFP, we don't have definites yet on the RFP process, but we certainly are going to try to raise as much interest as possible for obvious reasons. And that's for the debtor's benefit as well. Because
and what about splitting the Chile parcel, subdividing that? When is that projected?
Yeah, so that's one of the moving parts that all parties have been working on in good faith. What I think we've decided to do is when the transfer of property comes from the debtor to the county, we are going to accept out of that the Chile parcel, and prior to the closing of the transaction, we will have agreed upon a meets and bounds description of that parcel. So the Chile's parcel is never actually going to get conveyed to the county. In addition to that, we are working with the town, and the town has agreed that a subdivision will occur, but there are certain legal niceties that they have to comply with, notices, things of that nature, that will occur post-closing. So The property will always remain, at this point, this is what the parties, I believe, have agreed to. The Chili's parcel will remain in the debtor's hands, and the subdivision will likely be approved post-closing. In addition to that, though, none of the financial aspects of this transaction are going to be altered by how we handle the Chili's parcel, if you will. So the money's going to get paid. The debtor is going to collect rents, even if we had even contemplated that if the Chili's parcel had to be transferred up front, subdivided, and then transferred back to the debtor's still going to enjoy the financial benefits of the deal in terms of Chili's lease payments and things of that nature. But that I think everybody's on the same page as to how that's going to happen. The debtor is going to receive all of the benefit of the deal, though.
All right. And what about, my last question is, when do you anticipate you're going to do a plan? Presuming all this goes through.
We're working on a plan right now, and I think we're partially waiting to make sure that the settlement agreement would get approved so that we can move forward. And a part of the plan and the funding of the plan will be the funds that we receive from the county. So we're just making sure we have everything, all the boxes checked before proposing a plan.
All right. All right. Would anybody else like to be heard at this point? Ms. Thames, is there anything you'd like to add since Mr. Capriotti and Mr. Butler made their comments?
The only thing I would add, Your Honor, is that we do have a approval from the school district for the settlement agreement, and the town board is meeting this morning. We anticipate approval, but that's where our clients are in terms of the approval process.
All right. Does anybody else want to be heard?
Desiree Yagan, when it's my opportunity, I would like to be heard.
Well, you did not object to the settlement. You've only objected to the sale. Is there something you want to say about the settlement?
I apologize, Your Honor. I'm having great difficulty hearing, so I'm not hearing a lot of what's being said. So, yes, of course, this isn't the right time.
Do you have an objection to the settlement?
I have an objection to the sale.
Not to the settlement, correct?
No. I mean, well, I didn't even hear half of this. I expect to be able to review the transcript, but as I stated, I object to the sale. The settlement, the sale is the first and foremost on my objection here.
You were served with the settlement, correct? The motion to approve settlement, you've seen it?
No. No.
All right. Why not? You haven't seen it, even though you know of the sale?
Okay. See, you're fading in and out. As I told Donna and yesterday. Anyway, I'm not hearing you very clearly.
The point is, right now, we're not ruling on dealing with the sale. We're dealing with the motion to approve settlement. And if you want to address anything on the motion to approve settlement, I'll be glad to hear.
Okay, no, I just want to make sure that there's not a nuance there and I'm missing something. I'm not an attorney and I don't want to misrepresent myself. Okay, no, I should not be addressing this issue.
All right, so you don't have any objection to the settlement?
I'm not saying I don't. I'm just here to address the issue regarding the actual sale. The settlement, the sale is where my objection is, because I understand that in a Chapter 11 bankruptcy, that it is required that there's no encumbrances, that everything has been disclosed. But I guess I will address that when you inform me that it's the appropriate time. Again, I'm not clear on, I just don't want to say yes or no to a question that I'm not really understanding what it is. And again, I'm only hearing part of what was stated. But if you're speaking about the settlement, I object to everything because I can't imagine how they could proceed on anything. But again, what is appropriate, I'm not clear on that. But again, the letter that I provided in the court acknowledges on the 11th on Friday is stating that I object to the sale. I'm asserting that there hasn't been full disclosure, and certainly I will say that, and I think his first name is Kirk Berkery, however you pronounce his last name. He had sent me, anyway, I'm getting ahead of stuff, but I will tell you that I had received approximately 47 mailings of all the filings by the lawyers for Shoppingtown that were in my P.O. box after I found in my P.O. box after I had been released from my rehab center where I had been there a number of months. So I'll just stop here not to confuse the situation. But I just, again, I want to speak at the appropriate time. But I do understand I did read something to the effect that there's a $3.5 million cash agreement. And as far as the other, in the sale of Shoppingtown, I'm not familiar with all the issues regarding what was agreed on everything, and that doesn't even matter to me. What matters is I object. I understand pursuant again to Chapter 11 and bankruptcy court. It is absolutely required that every encumbrance, and I'm not an encumbrance, all parties and are aware of Desiree Yagan. They are aware of the tremendous civil liability. Shoppingtown Mall, where I was hit by a car in the parking lot on November 30th, 2017. The Shoppingtown Mall security. He is cited in the police accident report written by a officer, Kevin Skavinsky, and he states he reviewed the security videotape, and there was nothing on the video regarding showing the woman pulling out the parking space and running her car into me. But the fact of the matter is there was never a incident report filed by security. I contacted the security when I was in upstate hospital for a week, and they advised me that ultimately the head of security, Mike, he stated that they have had their cameras operating for over a year. So there are issues that I believe that absolutely has to be determined what's true. And by the way, I'm looking at a letter October 23rd, Your Honor, 2018. It's addressed to Shoppingtown Mall. Attention, CEO and Senior VP. That would be CEO and founder Steven Maksin and Senior VP Shaw Pryor. And that was hand delivered to the security, to the office there, and it said, subject notice of serious bodily injury lawsuit, vehicular assault, November 30th, 2017, resulting in fractures, torn ligaments at Shoppingtown Mall in the parking lot. And that was hand delivered, and it's and I requested, by the way, Your Honor, I said, notice of pending lawsuit, demand copy of incident report, request copy of the security video footage of mall parking lot. I don't believe that anything was ever filed. I mean, they never responded, and they just ignored my follow-up calls. I went there and visited the security.
Right. Interrupt you because I don't know how this is relevant to this motion to settle. Did you file a claim in the bankruptcy court?
No, I did not, but they had actual knowledge. All the parties have actual knowledge of this. It's the extended circumstances that prevented me from doing that, which I can't get in. Obviously, the court would require. Let me say this, Your Honor. That the police exit report states on there, in the narrative, the police officer states he reviewed the video with the security. They never filed a report. If they didn't file, I would assert to Your Honor that if the security for Shoppingtown Mall did not file an incident report, didn't notify the insurance company, then that would be fraud. That I assume that would
Ms. Yagan, I'm going to cut you off again because I don't know what this has to do with the settlement. We are here on a motion to settle. It sounds like you have some personal injury claim or some type of claim. You have to file a claim with the bankruptcy court. You file in the case. You have to file your claim. Maybe there's insurance. I don't know. I will instruct Ms. Weinrich and Mr. Berkeley to talk to you after we're done with this. But right now we're on the motion to settle. I have to focus on the issues that are here. All right? So I don't know. Whatever the issue is, it's for another day as to whether you got, whether somebody helped you, didn't report it, reported, all those things. My question to you is the settlement. And it's my understanding you do not have an objection, correct? To these people entering settlement.
The sale, not the settlement.
All right, let's proceed. Ms. Weinrich, let's go on to the sale, and then I will also roll on the settlement at the end.
Thank you, Your Honor. So as I mentioned at the beginning, the sale motion is really an extension of the settlement agreement. It provides for the sale of the mall pursuant to the settlement agreement, including the 2 out parcels and those leases that go with them. The reason that we filed the sale motion in addition to the settlement agreement is because we spoke with the county and they brought to our attention that if they would have proceeded with the foreclosure action and the foreclosure sale against the property, then that sale would have cleansed the property, setting it up for the RFP sale. So in the spirit of the proposed settlement agreement and in the interest of time, the debtor agreed to do a 363 sale to the county. So by doing that, it would give the county the same clean title that they would have received in a foreclosure sale. I think we've noted this before, but all creditors and parties in interest did receive notice of the sale, even though it was an expedited timeline. It was only by a couple of days. And we also did follow your local rules and provided publication in the local Syracuse newspaper. So that was published on November 29th and provided that there was a private sale of the property that would be occurring on December 14th, that there was a hearing, and that would be sold to the county. So while we do recognize that courts may be less inclined to approve a private sale that is not public, subject to the public or competitive bidding, we think that the private sale was necessary pursuant to the terms of the settlement agreement. And if the sale were a public sale that had bidding, the terms of the settlement agreement, including the resolution of all of the disputes and the release of all claims of the taxing bodies, those would be sacrificed to the detriment of the debtor. So in deciding to do a private sale rather than a public sale, the debtor exercised its sound business judgment as required by the Third Circuit to approve the sale. We would also just state for the record that we think that the sale yields a fair and reasonable price. The parties have acted in good faith, and as stated before, there was accurate and reasonable notice of the sale. We did receive one objection, and that was of Ms. Yagan. She's touched on it a little bit. I don't know if you would like me to address that now or if.
Well, here's my point. From having heard her prior in the settlement, which she was kind of addressing her problem, have you looked into her claim at all? What is her situation?
So, Your Honor, based upon the letter that we've seen, and I invite Mr. Berkeley or Mr. Capriati to add to anything that I say if they have additional information, but it doesn't seem like the claim is actually against the debtor. We think it's against other entities. Like she stated, there was no proof of claim filed, and I believe this is the first time that in the hearing that we've actually heard about claims against the debtor.
Well, it must be listed on the schedules, though, if she's been getting served with things.
She is listed on the schedules. She's listed as a potential unsecured creditor with the schedules list her as a disputed contingent unliquidated creditor with the claim of $0. So I think that was done out of an abundance of caution, but even the letter that was filed, it doesn't seem to assert a claim against the debtor. We believe that they're against different parties, and we are working on some revised proposed orders that we do plan on having filed as soon as Your Honor would like us to, but we don't plan on putting anything in those orders that would affect her claim against any other parties. We think she'd be, we don't understand how the sale of the property really impacts her right.
I totally agree with you. That's why I wanted her to express to me what her position was, because I don't understand how this is affecting her in any way, but we'll hear from her in a minute. Mr. Capriati or Mr. Berkeley, do you want to add anything to that before I let her speak?
No? Thank you, Your Honor. Yeah, in terms of the sale and Ms. Yagan's objection to it, I think I understand what the claim is. I don't believe it impacts the county at all. More to the point, I don't believe that it impacts the sale at all. If there is a claim, whatever that claim may be, I'm not sure if Ms. Yagan understands that whatever her status as a claimant is going to attach to the settlement proceeds, and that it really are the proceeds of this sale, and she would have to assert whatever claim that she has in this bankruptcy court and follow whatever procedures the court has established. But in terms of an objection to the sale, I don't know that anything that she has raised in her papers would prevent the court from approving the sale. So from the county standpoint, we believe that the sale should go forward.
All right. Ms. Yagan, yes. Why don't you address your objection to the sale? Because I think we, the people that have been heavily involved in this case for a long time, do not understand your objection as to a sale. If you have a claim, as Mr. Capriati clearly indicated, you will transfer to whatever interest you have. Now, please address why you have an interest in this estate when you haven't filed a claim. It sounds like the debtor listed is disputed. And from what you originally said orally and what you filed with the court, it seems you have a claim in general against some damage that was caused to you, but not necessarily against the debtor. But please address your objection so we can clearly understand if that's what you're trying to object to.
Okay, first of all, Your Honor, it's important to state that I abruptly had to draft a letter, and it took, anyway, once I discovered that this, in fact, the newspapers in Syracuse stated that the sale had gone through, that some of them weren't very clear, that it requires a ruling from the bankruptcy judge in this case, Your Honor. But nonetheless, once I saw that, I immediately contacted the court. Now, and again, I just became aware of this. Now, as far as the sale, let me try to be clear here. First of all, and I guess that's what I want to say, and I did say clearly a minute ago, is that I haven't had time to address this issue. I just found out Friday about this, and then I abruptly drafted a letter. I attached a document. I scanned the document to the two-page letter of to the issue regarding Shoppingtown Mall, and I understand the court is telling me, and I'm being informed that this is whatever claim there would be, that I would not be denied the claim simply because the sale is that. Do I understand that correct?
Well, you haven't filed a claim, so you may be denied a claim, an interest in these monies at a later time because you've passed up the deadlines. Plus, you have to prove that you have a claim against the debtor. But even if you did have a valid claim against the debtor here, you would be transferred. This money will be distributed at some other time through the plan. So back to you, the question is, why would any creditor object to the sale? You have to have some merit to your objection. not just an objection that says I'm owed money.
Yes, and the first objection is I understand that whenever there's the reading of under Chapter 11 and bankruptcy, that the debtor, whoever's filing the Chapter 11, that they are required to disclose every claim, every asset, and encumbrances. And the issue is this: is if the claim that I have against Shoppingtown Mall isn't simply civil. They never. I'm asserting that that the fact that they never filed a incident report to the insurance company, that would be fraudulent concealment in that issue. Now, as far as the level of claim and why I haven't filed the claim, I can present to the court a good cause, good reason, justification. It has been impossible to proceed on this claim to file it. But this actual sale, before it could take place, I assert that, and maybe I'm incorrect, but if the person was severely injured in the parking lot in Shoppingtown Mall Security, Moonbeam Capital Investments, that and that individual, the two that I cited in that letter here, that would be Steve Maksin and Senior VP Shaw Pryor. I hand delivered the letter. I am being obstructed from accessing and having them file. They refused to file an incident report regarding the severe physical injuries that were incurred and preserve the videotape. They never served. That means that they didn't take an incident report, Your Honor. That means they never filed with their insurance company. They cannot conceal incidents on the parking lot or on the property from the insurance company. The fact that I haven't filed a lawsuit is due directly to the circumstances and the serious bodily injury and months in the rehab, and then coming out and having to deal with multiple interrelated issues regarding the vehicular assault. That the police officer states that the motorist stated that the pedestrian fell. She broke my legs, and the fact that it's inextricably intertwined, I assert, Your Honor. The fact that this woman pulled out of a parking space, states that in the police accident report, she pulled out of the parking space at less than 5 miles an hour. You go with that narrative that the police officer put on page 1 of the police accident report. The motorist stated she pulled out of the parking space at less than 5 miles an hour. She saw the pedestrian standing in front of her, stopped her vehicle, met eyes with the pedestrian, and then the pedestrian fell to the ground. And then on page 4, fast forward, and the officer states I refused. Everything he stated was false. He had his own false statement. Stated I refused to give a statement, and then so on. On page 4, you look at the police diagram, Your Honor, and it shows the vehicle is over me on the wrong side of the road.
All right. But Ms. Yagan, I don't want you getting into your claim. It has nothing to do with this sale. That's for another day. If you want to file a proof of claim here and you have to file it now, it's late, so you'll have to get a motion in. You need to have some basis and some merit to the objection to the sale. Everything you've told me is not an objection to the sale. The sale is fair and reasonable. It has
a serious injury. Would that not, if there is any possibility that there is fraudulent concealment or them not filing a incident report?
You'll have to bring that action at another day. That doesn't have anything to do with the sale. Has nothing to do with the sale.
Okay. See, I'm not clear on the. I just understood when I read the Chapter 11 and the rules under Federal Rules of Civil Procedure that the requirement is full disclosure. Any claims, any encumbrances, any known claims.
Well, this court, any claims or anything you have gets transferred to proceeds, but it does not have. I don't think you have an encumbrance. I don't think you're in a position, you don't have a lien or an encumbrance. You may have a claim in this estate. That's what it sounds like. But either way, this is not an objection basis for a sale. You have to come here and explain to me and have proof that it's not fair and reasonable to do this sale.
Your Honor, I asked that for let me just, I asked for an adjournment so I can present this properly. Do this with, I can't hear what I haven't reviewed, and I can't. No person should have to an unusual exigent circumstance, Your Honor, as I'm asserting my position is to present to the court sufficient cause or to respond properly because I just filed this on Friday. I just became aware of it, and maybe there is nothing that would maybe there's no merit or no justification for me to make an objection, but I can't make it confident. I can't present it whether it does or not. I don't know for certain, but I do know for certain that I can't possibly make my objection without a few days or a week to address the court. And I could do it concisely, properly, instead of scattered and like this because the duress of, trying to understand the Zoom and then can't do that, can't do
all right. Okay. We have given you, let me just indicate, I'm overruling any objection that you have to the sale because I don't think there's any merit to your objection as to the sale. If you have some claim in the estate, please proceed with that. But as to the sale, this objection has no merit, and my ruling is that she's been given adequate notice to proceed with, and having responded, she responded late, and there is no merit to her objection to the sale process in this case or to the settlement. Therefore, I feel that the sale, after a review of this case and the history of this case, is fair and reasonable, that the parties have acted in good faith, and this is the best for all creditors. And the sale should proceed because it benefits all creditors. As to Ms. Yager, if she has some type of claim, I hope that she can pursue it wherever she needs to, if it's in this court or somewhere else. But as to the sale is approved. Does anybody have any comments? All right.
Your Honor, I would just, oops, sorry.
Yes, go ahead. I'm sorry.
I just wanted to say again that we are working on slightly revised proposed orders, so we will be uploading those.
All right, that's fine. I just want you to understand that Ms. Yagan's, the ruling here does not affect any potential claims she may have. That'll be dealt with in another time, another forum maybe, but the sale is approved because it's fair and reasonable. As to the settlement, the court has reviewed the Martin factors, and I feel that it's fair and equitable, that all the factors have been met, that the possibility of successive litigation and the difficulties in collection and the complexity of the litigation is basis for approving the settlement. This settlement was worked out in good faith, and I know it took many hours to do, and I think it's very beneficial to the community as well as to all the creditors of this estate. And I commend all of you for working so hard to getting it done. All right, so both of them are approved. I will wait for revised orders. Is that what I should be looking for?
Yes, Your Honor, and we can call your chambers when.
Yes, do that because we'll download them as soon as you get them, and we'll try to get them entered because I know that you want to have a closing before the end of the year. I know you have to fill in some dates, some document numbers, and if you want to correct that agreement at that point, you can refer to that too. Whatever way you all work out a good order is fine with me, probably. If I have a problem, I'll call a fast hearing, but I doubt it. Does anybody else want to be heard?
Your Honor, will I have an opportunity? Number one, I asked that I could have a transcript of this hearing because I only could make out part of it, and I respect the court's decision. I do request that that I have an opportunity to speak with. Is it in regard, once this is now determined that the sale is granted by Your Honor, can I still speak with the trustee, or is this not appropriate?
There's no trustee, and I cannot give you instructions on who you can speak to. But I would suggest that you consult an attorney or proceed whatever way you need to. There is no trustee in this case.
Oh, there isn't. Okay, I saw a name of a trustee on the docket. I must have been a mistake. Okay, sorry.
Anybody know what she's referring to?
Judge, I would assume that it's the United States trustee.
Yeah, all right, they are not, they just supervise the case. They are not in, there's not a trustee appointed in this case.
Oh,
Thank
see,
you.
Your Honor, there's a distinction. Okay, thanks.
All right, anybody else want to be heard? All right, congratulations, you get this done before the end of the year.
Thank you, Your Honor.
Thank you, Your Honor.
Thank you all.
Thank
Happy
you.
holidays, stay safe.
Thank you.
Thank you, Your Honor.
Bye-bye.
Thank you, Your Honor.
We can close the record.